So people used to ask if you can use your SHS certificate to enter into law school straight away. No, that's not the whole process. Today I'm going to show you how the process is being done. I'm going to interpret it one after the other. I'm going to explain it one after the other for you to understand it very, very well. Even me, when I completed school, I wanted to read law, but I was finding the whole process very confusing and very difficult. But today I'm going to make it simple for you. So please, if today is your first time watching me, please do me a favor, subscribe to my channel, like, share, so that YouTube can recommend my channel to others to also watch it. So the study of law is divided into two parts. We have the substantive law and procedural law. So the substantive law, which is offered in the most law faculties in the country's public and private universities, requires one with a first degree or SHS certificate to pursue it. So a candidate with SHS certificate would have to offer the course for 4 years, whilst a first degree entrance offers the course for 3 years. Before you can pursue a substantive law, you have to have a first degree or your SHS certificate that you already know. If you want to use your SHS certificate to pursue a substantive law, you have to offer the course for 4 years. So with those who have first degree, have to offer it for 3 years. So after you are done with your 4 years or 3 years course, then they will award you with LLB certificate, of which it is equivalent to a first degree in law. LLB stands for Bachelor of Laws. It's an undergraduate program which is being offered for 3 or 4 years. Graduates of LLB would have to pass a competitive entrance laws, which would qualify him or her to enroll into the professional law program in Makola, which is known as procedural law. Person with SHS certificate is nowhere close to Ghana School of Law. If you find this helpful, good information, educative, please do me a favor, subscribe to my channel, like, share, so that YouTube will recommend for others to also watch it. I am Mama Ba Ramat. You can call me Mama Ba for short. Thank you.
In the High Court of Justice, in the matter of the Republic versus Dr. Smart, this court is now in session. Her Ladyship Justice Gertrude Amar presiding. Dr. Smart is standing trial for unlawful abortion, contrary to Section 58 of the Criminal and Other Offences Act 1960, Act 29.
Legal representation.
Respectfully, my lady, Custodia Champomadomi, a principal state attorney, and with me are Yasmin Abdul Kudus and Frankwe for the state.
Yes.
Respectfully before you, Ohileba Brumpono Ruswado, with me, Davis Obriabwa and Prosper Indiba, representing the accused.
You may proceed.
With your kind permission, my lady, I would like to proceed with the cross-examination of the witness from where we ended at the previous session of the court.
Dr. Smart, you are reminded of your previous oath before this court.
Dr. Smart, you indicated at the previous session of the court that you were compelled to conduct an unlawful abortion on Miss Ichiwa. Is that correct?
Objection. This very question is prejudicial to the outcome of the case. The court has yet determined the lawfulness or otherwise of the procedure to justify this very question.
Objection sustained. Counsel, please rephrase the question.
I'm most obliged, my lady. Dr. Smart, you indicated that you were compelled to conduct an abortion on the victim. Is that so?
Yes, my lady. I would also remind this court that the lady was in excruciating pain and in danger on missing out on her final examination. Also, her condition was deteriorating and was clinically dangerous. That is why I performed the procedure on her.
So you prefer breaking the law to help your patients write an exam?
My lady, my Hippocratic oath does not allow me to suffer a patient without treatment. I acted in accordance with my professional training.
Now, Dr. Smart, when a patient presents at your clinic for abortion, are there standard protocols you observe as doctors before conducting such abortion?
Yes, my lady.
And did you observe these protocols?
Yes, I did.
Kindly state them for the record.
My lady, when we are faced with such an issue, we determine if there's indeed a pregnancy. Where there's a pregnancy, we make an overall health analysis of the patients, checking the gestation age and also checking for complications. Also, we take the patients through guidance and counseling before we start the whole procedure.
Now, I'm going to ask you 4 specific questions and I need nothing but a yes or no answers to that. First, in your judgment, was the patient's life in danger when she presented?
No, my lady.
2, did she complain of having been raped?
No, my lady.
Again, did she state that she was consanguinely related to the father of the fetus? My lady, need I remind the witnesses under oath and as such, answer the questions accordingly.
You may answer the question.
No, my lady.
Lastly, did she appear to be mentally ill?
No, my lady.
So you do concede, doctor, that you conducted this abortion in furtherance of your own criminal enterprise simpliciter?
Objection. Prosecution is indulging name calling and berating the witness, and same should be furthered by this honorable court.
Objection overruled. You may answer the question.
My lady, I am not engaged in any form of criminal enterprise.
You agree, doctor, that you conducted this abortion knowing it was not permissible under the 4 stated grounds by law?
My lady, the procedure seems unlawful. However, I am justified by my Hippocratic oath. I do not see any wrong in what I have done.
You realize, doctor, that your behavior is degrading of your calling and barely rises beyond that of a quack.
Objection. Calling the witness names only betrayed frustration of the prosecution, and ipso facto must be called to order.
Sustained. Please rephrase the question.
I'm most obliged, my lady, but respectfully, there will be no further questions for the witness.
Having considered the statutory framework governing lawful termination of pregnancy, as stipulated in Section 58 of Act 29, the court identifies only 4 permissible grounds upon which an abortion may be carried out without constituting an offense. First, where the pregnancy is a result of rape or defilement of the victim. Second, where the continuation of the pregnancy poses a risk to the life of the victim or the unborn baby. Third, where the pregnancy arises out of incest. And finally, where the victim is mentally ill or an imbecile. In agreement with the prosecution, the procedure in question has been conducted by the accused person without recourse to the provisions of the law under Section 58 of Act 29 and is accordingly unlawful. In determining his punishment, I am influenced by 2 key extenuating circumstances. The fact that the accused is a first-time offender and the fact that he was driven by his feelings of humanity for the plight of the victim in violating the law. I will accordingly sentence him to the minimum punishment of 5 years in prison.